The Senate Judiciary Committee will come to order. Thank you all for joining us. And the agenda for today is to work some bills that we have previously heard. So the first one we will take a look at is a bill that we heard earlier this week, and it is Senate Bill 385, requiring registration as a sex offender for certain violations of the crime of breach of privacy. And we had, there were 35 co-sponsors in the Senate of that bill, and so we're going to turn our attention to the bill brief and work the bill. So with that, Reviser Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So as the chairperson was explaining, Senate Bill 385 is the dealing with the crime of breach of privacy, certain violations of that crime that would require you to register as a sex offender. Under the current law, you can be required to register for this crime, but it requires a special finding of sexual motivation, and that is sometimes difficult. So frequently folks that are convicted of this crime are not required to register. And this would make it automatic. So if you're convicted of this crime under one of the three subsections that are listed, then you would register as a sex offender and you would register for 15 years. I did note a mistake in my bill brief. I only referenced subsections A6 and A7 of the crime. The bill actually has A6, A7, and A8, which is as it passed the Senate a couple of years ago. So the bill is correct. The bill brief is incorrect. So I just wanted to point that out. So that would be violations of A6, which is installing or using devices to take certain images without the consent of the person. A7, disseminating or permitting dissemination of those images. And then A8 is disseminating images with intent to harass, threaten, or intimidate an identifiable person. That was kind of referred to as the revenge porn bill a couple of years ago. So this includes A6, A7, and A8. And I think I only talked about 6 and 7 last time, so I wanted to be clear on that.
Thank you. Committee questions for the reviser. Do we have any amendments? I wanted to bring it to the committee's attention that when this bill passed out of the Senate and over to the House in 2020, the House Judiciary Committee made a couple of amendments, and they weren't considered in the House because the legislature adjourned due to COVID in March 2020. So one of the amendments that they had considered in committee there was whether the bill or the law, when it's enacted, should apply to an offender who is a juvenile. I have heard, a lot of juveniles have phones and access to these sorts of devices, and do we want this to apply to juvenile offenders, those who are under 18? So we'll just open that up. I do have an amendment we can look at if that's something we want to consider as a committee, because it's quite a severe penalty, and we want to make sure that we are fully aware of the consequences, and we are very mindful of what policy we're putting out there. So yes, Senator Thompson.
Do you have an amendment that would adjust this so we can kind of consider what you're thinking?
I do. I have an amendment. If the reviser and research would help pass that out, and the committee assistant, that would be helpful. And the reviser can explain it, but I'll get started just a little bit. It's on page 6 of the bill, essentially, and we're passing that out, and we'll wait for that to be passed out and then ask the reviser, Mr. Thompson, for an explanation.
All right. Thank you, Madam Chair. Jason Thompson again. So as you mentioned, the amendment, there are some commas added in a bunch of places. There's this phrase, which if committed by an adult would constitute the commission of a crime. There's supposed to be commas around the if committed part. So I'm adding that as part of this, but that's not necessary. It's just something that we're doing as we catch it. The change is on page 6, the substantive change. What you note at the bottom of that page, this is section 1, 224902, where the definitions are. So we're defining offender, and we're defining sex offender, and all the other terms here. But then there's this provision, subsection T, at the bottom, that's current law, that says, essentially, offender shall not include certain persons, right? And currently, we have one where we don't include certain persons convicted of unlawful transmission of a visual depiction of a child. We have persons who are adjudicated as a juvenile offender for the commission of that crime. And we have persons adjudicated as a juvenile offender for the commission of sexual extortion as defined in another statute. So we have 3 examples there now. And this would add a 4th. A person adjudicated as a juvenile offender for an act which, if committed by an adult, would constitute a violation of 216101, A6, A7, or A8. And those are the 3 violations of breach of privacy that you're adding in this bill. So this provision would essentially just say, despite what we said earlier about you being an offender, it will not mean a juvenile adjudicated for those breach of privacy offenses. So it would only apply to those folks that are convicted as adults for those crimes.
So it could apply to someone under 18, but they would have to be adjudicated as an adult and go through that process through the judicial system when the court deems you as a juvenile should stand trial as an adult. And we do have then that mediating process there that the court would have some discretion, even for someone under 18, that they should be adjudicated as an offender, and the prosecutor could too. Am I understanding that correctly?
Yes.
Mr. Revisor, sorry.
Thank you, Madam Chair. Jason Thompson again. Yes, and I kind of glossed over that. I appreciate you highlighting that. I was being very careful with the words because what you said is accurate. If you're adjudicated as a juvenile offender, that means you were tried as a juvenile under the Juvenile Offender Code 382301 at SEC. But you can be tried as an adult, as a juvenile. It requires a special motion, moving you to adult court. So you're no longer a juvenile at that point. You're tried as an adult. So you're correct. If you're tried as a juvenile, no registration. If you're adjudicated of that crime. But if you're tried as an adult and convicted of that crime, regardless of your age, you would be required to register. So that is an important distinction.
Thank you. If the committee's clear on that. So even someone under 18, if they are tried as an adult, this bill, if it were to become law, would still require them to be registered as a sex offender. So with that, committee, any discussion on the amendment or, yes, Senator Corson.
Thank you, Madam Chair. I appreciate you raising this issue, and I appreciate you bringing this amendment for our consideration. I would be inclined to support this because this is a serious offense. People who commit it should be punished appropriately and appropriately severely, but I think that you have, and this amendment addresses a real point, 15 years for somebody who's adjudicated, say, for example, as a 15-year-old, adjudicated as a juvenile, having to register until they're 30, and the impact that could have on college, post-college, grad school, career, being hired in various professional opportunities, up until that person's 30, is quite a substantial thing. Again, obviously not minimizing the severity of the underlying action for which they very much should be punished, but I think that's important, and I would be inclined to support this amendment, and I appreciate you raising and bringing this. Thank you.
Thank you. Other comments on the amendment? I would add that it seems, I think we always try to strike a balance in what we do in the State House, and it strikes a balance between the need to obviously bring to the court and stop this bad behavior by individuals. And again, appropriately, it would allow some look by the prosecutor on whether to prosecute as an adult or a juvenile, and it would be providing some avenue to be appropriate in how we look at how we're going to prosecute this very heinous crime, and still take into consideration who the victims are as well. When we, as a system, decide, well, is this juvenile going to be prosecuted as an adult or as a juvenile, given the particular circumstances of the activity that occurred? Yes, Senator Thompson.
I too want to say that I think this is a good amendment. You know, there's a big difference between somebody who's 13 and somebody who's 18. So given the latitude of the courts to be able to move a 17 or 18-year-old up and try as an adult, I think is a good idea, because this is something that's, you know, the cell phones are out there, it's happening, and it's very serious in nature, but I do support this amendment.
Well, thank you. And if we have no further discussion, then I will move the amendment if there's a second. Senator Corson. Committee, any further discussion on the motion? You've heard the motion, then all those in favor, aye. All those opposed, no. The motion carries. We're back on the bill. Do we have any other amendments on the bill? Seeing none, then I will entertain a motion. Senator Thompson.
I was pointing to Senator Baumgartner.
Sorry, Senator Baumgartner.
Thank you very much, Madam Chair, and it is exciting to be able to get this pushed out again for the Kansas Senate to vote on again. So I do move that we pass out Senate Bill 385 as amended favorably for passage.
Senator Thompson for the second. Thank you. Committee, you have heard the motion. Any discussion? Seeing none, then all those in favor, aye. All those opposed, nay. The motion carries. And I want to thank the work of the committee and also of the brave women who came forward and provided testimony. And we now have some forward momentum on getting this enacted into law. It will pass out to the Senate as a whole now, and where it will be subject to debate. And if it comes above the line in the process, and we will be working to make sure as best we can that that happens, and to give our prosecutors some additional tools regarding this activity. So with that, committee, then we will turn to Senate Bill, thank you, losing my place in line here. Senate Bill to Senate Bill 434, which is creating exemptions in the Open Records Act for records that contain captured license plate data or that pertain to the location of an automated license plate recognition system. With that, then, we'll ask our reviser, Mr. Thompson, for a bill brief.
Thank you, Madam Chair. Committee, you'll recall this is the bill you heard just 2 days ago, I think, on the 9th. The three amendments in the bill. First, you've got an amendment to 45-217, defining automated license plate recognition system and captured license plate data. Remember, this is the data, such as the date and time, photograph, license plate number, et cetera, derived from the system, and then the location of the actual system itself that would be protected. Section 2 is the Open Records Act statute, where we actually add the exception to disclosure. So a public agency will not be required to disclose information about the location of one of these systems or about the data that's derived from those systems. That's under 45-221. I'm sorry, I skipped to section 3. And the section in the middle, 45-220 that I was mentioning, just says that if you're requesting records from an agency, you actually have to request them from the agency that owns, leases, or contracts the system. So you couldn't, for example, go to ks.gov and ask for the records when the folks owning or maintaining it are an actual law enforcement agency. You would need to go to that agency for the records and let them grant or deny your request. So yeah, there's three parts. The first would be the definitions. The second is this where you request the records item. And then the third is the actual exception that says you don't have to disclose these records.
Thank you. Committee, any questions for the revisor? Any discussion on the bill or amendments? Yes, Senator Gossage.
Just a quick question. I had somebody ask me about this bill, and the question was, evidently they had been ticketed before because of one of the cameras, and they didn't feel that that was their vehicle. They weren't there at the time. They had requested if they could get a copy of that proof, of who they were, and wanted to know, could they still do that with this bill?
Thank you. Revisor, Mr. Thompson?
Madam Chair, so generally speaking, if there was a citation, you've got a traffic citation, you've got something you can challenge, and so you would have a means to do that through the legal process. The Open Records Act request is just the general public making a request, and that's what this situation is addressing. So I think if you have an actual case, in this case, a traffic infraction or a traffic citation, that's one situation. But if you're just asking for general information about the location of one of these systems, or you're asking for data from the systems, then I think you're subject to the general KORA rules. And this goes back a little bit to the discussion we had in committee about if you have an actual criminal case or even a civil case where there's an evidentiary issue with some of this information, you can, of course, get a subpoena and go get this information. It's not confidential. It's just not subject to the general Open Records Act provision that requires it to be open to everyone. So I think in your case, it's the traffic citation, probably okay. In the cases we talked about where you'd be doing discovery, you're probably okay. This is just the general public that would be prohibited from coming in under KORA and getting the information.
Thank you, Mr. Thompson. Thank you, Madam Chair.
Committee, other questions or discussion or amendments? Seeing none, then the chair would entertain a motion. Yes, Senator Gossage. I think your mic isn't on.
Sorry. I move that we pass Senate Bill 434 out of committee favorably.
Is there a second? Thank you. Oh, Senator Thompson, thank you. Committee, you've heard the motion. Any discussion? All right, then, all those in favor, aye. All those opposed, no. The motion carries. Thank you, committee. We're next going to take a look at Senate Bill 435, which expands law enforcement officers' jurisdiction to include situations when an illegal act is observed that the officer reasonably believes will jeopardize the safety of any person without immediate action. And we'll ask for a bill brief from the revisor, Mr. Thompson.
Thank you again, Madam Chair. So the committee will recall this bill also from the 9th, just a couple days ago, brought to you by the law enforcement associations. Essentially, we're just amending the statutory jurisdiction provision for law enforcement. It's KSA 22-2401A, and as the proponents clarified for you, there are other statutes that deal with jurisdiction of law enforcement officers, particularly statewide officers like the Highway Patrol, for example. They have their own statutes. This statute is for everyone else, essentially, those who do not have statewide law enforcement authority or more specific authority. So this would be, law enforcement officers for the county, for the city, for the Horse Thief Reservoir, for the Adjutant General, et cetera, those listed in this statute. And so some of it is cleanup. We're just moving language around to be consistent in each subsection, and then putting some provisions down in subsection H that apply to every law enforcement officer listed here. Some of them are current law, right? So, for example, being able to go to a place where your assistance has been requested, when you're in fresh pursuit, when you're transporting persons in custody. Those are the three examples. Although it's not clear that every one of the folks listed in this section has that power, this would make it clear that they all do. There have been some inconsistencies in the language and some questions about whether certain officers had these powers, and this would make that clear. The other one is new, and that would be investigating a crime that occurred within your jurisdiction and you're going to another jurisdiction to investigate. That one, you heard about some case law with some issues with being able to go outside your jurisdiction, and then what happens with the evidence that you seized or found and whether that is excluded and how that harms cases. So you may recall that discussion. And then the other big change is a new subsection I, which is what the short title that we were talking about references, that would allow all these law enforcement officers to have jurisdiction in situations where they're observing an illegal act that they reasonably believe will jeopardize the safety of another person without immediate action. So this is that driving along, you see an incident of some kind that you believe will jeopardize the safety of someone, and you feel like you need to act immediately. You're a law enforcement officer that meets the requirements of the section. For example, you're driving to and from training, or you're on on-duty status, but you're out of your jurisdiction. You can stop. You can address the situation, and then you're required to stay, work with the local jurisdiction, make reports, et cetera. So there's a number of qualifications to this new jurisdiction option, but it would be codified here. And I would note, because the proponents made it a major point of emphasis, your own jurisdiction can limit your authority under that subsection. So, for example, if I'm a horse thief, reservoir, law enforcement officer, the folks employing me may decide that I should not have that authority, and they can limit me under subsection I. So it is left to the individual jurisdictions to decide whether their officers have this power or not, but the default would be they have it unless they're otherwise restricted. So hopefully that brings everybody back up to speed. I'll answer any questions if you have them.
Thank you. Committee questions for the reviser. Senator Haley.
Thank you, Madam Chair. Appreciate Mr. Thompson. I was really surprised during this hearing that some of the questions weren't raised about this expanse or extension for police powers. I guess my question for Mr. Thompson is, am I misreading this, or is this just a modicum or a small extension of what is already available to those who are duly authorized to conduct law enforcement activity? Is it really just a small change from what they can already do, or is it a larger expanse of that? Can't they already do most of this anyway? I mean, what are the significant changes, I guess? Because I would think that if you're in one jurisdiction and you witness or believe you're witnessing an ongoing crime, and you have your equipment or weapon about you, that you're able to, they used to call them citizens arrests, if you will, that many of lay people could do some of this, even apprehend and hold until law enforcement gets there. But is it that significant an expanse from what can already be done?
Thank you. Mr. Thompson?
Thank you again, Madam Chair. So, generally speaking, all of the law enforcement officers listed in this section have the four powers listed in subsection H on page 6, right? So they have the power when they're requested to go somewhere to assist. They have the power in fresh pursuit to have jurisdiction, and they have the power when they're transporting persons. Some subsections did not make that clear, and we have some case law that said, for example, a school officer or an officer from one jurisdiction that went to another jurisdiction, it was the school officers who said they actually did not see authority to go even when requested, right? That was one of the pieces of testimony we heard, because they didn't have the specific request for assistance provision in their subsection. They thought they didn't have that power. But by putting it here, we make it clear that they do. So there may be an expansion of powers to some of these officers just on provisions that are not consistent. From what I remember and what I've learned in the drafting and the hearing, the new H4 about investigating a crime that occurred within your jurisdiction, but you go to another jurisdiction to do it. That was the case that they discussed, the proponents discussed, where an officer in one part of Johnson County went to another part of Johnson County to do an interview, essentially, ended up seizing evidence, but they were out of their jurisdiction, and that evidence was then tossed out of court. The case was lost because of it, and so the court essentially said, your statute did not say you could do that, so we're saying the legislature is not allowing you to do that. That's essentially what we had in that case. So there's at least an argument that that authority might have been there before, but that was declined, at least in that one case. And so this would make clear that all of these officers have that authority. You're investigating a case, you go somewhere else, you still have your jurisdiction to be there because you're investigating a case from your own jurisdiction. So that one is maybe a small expansion, maybe a large expansion. It depends on your perspective. But the big one that is definitely new is that subsection I, and that's why I spent most of the time focusing on that one, because there is some indication that you can always stop to protect the public when you're a law enforcement officer, right? Or even citizens stopping to help other citizens. But we were told from the conferees that because this jurisdiction statute is so specific about certain times when you do and do not have jurisdiction, there's a worry that you might not have jurisdiction if we don't spell it out. If the legislature doesn't put that provision in here, that there might be a case where they stop, they assist, they arrest someone, and it's found to have been unlawful because they were actually not in their jurisdiction. And I think they're trying to head that off before it happens. So it is an expansion. I guess that's from the neutral perspective that I'm giving you. It is an expansion of the powers. To what degree is maybe a little more nuanced, and so there's a little bit of just, I'm distilling what we heard from the conferees. It might be a bigger expansion to some, and it might be a very minor expansion to others. But it is definitely an expansion, or at least a clarification of some powers that certain officers in here may not have right now. I know that's a long answer. I apologize.
Oh, it was a long question, so thank you, Mr. Thompson. I appreciate it, and thank you, Madam Chair.
Thank you. Committee, other questions for the reviser? Any discussion on the bill? I want to remind the committee, based on the questions, we did hear testimony in support from the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association, the Blue Valley School District Director of Safety and Security, who's also Chief of Police of that division, came and testified in support. We also had proponent testimony from Special Deputy Sheriff for Government Affairs from the Johnson County Sheriff's Office and from the League of Kansas Municipalities. And we did not have any opposition testimony to the bill. So with that, do we have any amendments or any further discussion? And seeing none, then the chair will entertain a motion on the bill. Anyone? Senator Thompson.
Thank you, Madam Chair. I would move that we pass out Senate Bill 435 favorably for passage.
Thank you. Is there a second? Senator Gossage. Thank you. Committee, any discussion on the motion? Seeing and hearing none, then all those in favor of the motion signify by saying aye. Aye. All those opposed, no. The motion passes. Thank you, committee. We will then, I think it's important to provide law enforcement additional tools for their work that they do. And I think we've seen a resurgence in crime, and we need to be addressing that as best we can. We will then turn to working and final action on Senate Bill 419, allowing special agents from the Department of Corrections to attend the Kansas Law Enforcement Training Center. With that, we will ask for a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Senate Bill 419, you may all recall, you heard yesterday. And unfortunately, my short title is a little narrow, so I'm hopeful that I explained a little better in my bill brief than when we wrote that short title when the bill went in. The new section would allow the Secretary of Corrections, with the consent of the Director of Police Training, to designate employees other than special agents to attend the Law Enforcement Training Center or to attend other training courses and then get transcripts and certificates of completion and such. So there are employees of DOC that are not special agents that this would help to get that continuing education and training like a law enforcement officer would get, even though they're not law enforcement officers. And then Section 2 is an amendment to the Law Enforcement Training Act that would make these special agents of the Department of Corrections law enforcement officers. So they would be obligated to meet all requirements of law enforcement officers, including continuing education, attending law enforcement training center, all of that. And they would also get all the benefits of being a law enforcement officer that come with that. So there's kind of two parts to this. One for DOC employees that are not special agents to get them some law enforcement training, and then one for those who are special agents to actually make them law enforcement officers, just like the folks we were talking about before, or other folks that are currently under the Law Enforcement Training Act.
Thank you. Committee questions for the revisor. Yes, Senator Gossage.
When I looked at this earlier, then thank you, Madam Chair, I was struck by the fact that they were only anticipating 2 additional trainees. And so it says at a cost of $4,560, therefore enactment of the bill would increase expenditures by about $9,120. So I was just curious as if anyone knows, if we think that's what they're anticipating for 2023. If we're just talking about a very minimal amount and better training for folks, I would be in favor of this bill.
Thank you. Are you looking at the fiscal note?
I'm reading the fiscal note, yes. It's the 3rd paragraph.
Do we have any further information about the fiscal note from research or the revisor, or we didn't really particularly hear any testimony about that? If we can look to see from the Department of Corrections and the testimony provided there.
It just says estimates 2 additional individuals will require basic training each year as a result of enactment of the bill. Agency indicates it at near capacity in its facilities. However, 2 additional trainees would not present a concern.
Thank you. I think the revisor, Mr. Thompson, has a comment.
Madam Chair, if I'm recalling testimony from Mr. Bowman from the Department of Corrections, he was indicating they currently have these special agents who are essentially law enforcement, but without the title and without going to the full law enforcement officer status. So those folks probably already counted, I would think, for the Law Enforcement Training Center purposes, is kind of what I gathered from his testimony. I think the estimate of 2 additional is referring to that new Section 1, where the secretary can designate employees to go attend the center and get some training, but they're not actually law enforcement officers, right? These would be additional folks that are not being sent there now. But recall that provision requires the consent of the Director of Police Training, who oversees the Law Enforcement Training Center. So if they're saying we anticipate 2, I'm thinking that's them talking to the department and saying, we'll let you have 2. If they asked for more and they didn't have the capacity, they could tell them no, right? It requires that coordination. So the secretary could not, for example, say, I have 5 without the consent of the Director of Police Training. So it sounds like, just based on what they've presented to you, they see it as 2 or less, and they can kind of accommodate that. And that's probably where the fiscal note came from.
Thank you. Further questions? Yes, Senator Thompson.
Yes, in fact, and just dovetailing on what the other Mr. Thompson says, I asked him the question, remember, about that fiscal note, and he said, yeah, there would be 2. I further clarified, it said, is that going to be 2 going forward? And he indicated, as I recall, that no, he anticipated that the numbers would dwindle as they get the people trained. My concern was that, they're going to keep that number up in perpetuity, and that was not what he indicated in testimony, but that they would get people trained and then it would feather off and only as necessary be required.
Thank you for that clarification. Appreciate that. Committee, any other questions or discussion on the bill? Seeing none, then the chair will entertain a motion. Yes, Senator Haley.
Madam Chair, I certainly move that we adopt the recommendation and support Senate Bill 419 for the law enforcement training for Department of Corrections.
Thank you. Are we ready for a second then? Do we have a second? Senator Gossage. Any discussion on the motion? Hearing none then, all those in favor signify by saying aye. All those opposed, no. The motion passes. Committee, with the time that we still have left today, we have an opportunity to work Senate Bill 141. It would enact the Kansas Uniform Directed Trust Act. We heard this last session. We didn't have any opponent testimony, and it would help, like it sounds, bring some uniformity to this area of law. It was brought to us by the Kansas Judicial Council, who had studied the matter and wanted us as a committee to take a look at it. So with that, we will have a bill brief from the reviser.
Thank you, Madam Chair. So, as you mentioned, Senate Bill 141 would enact the Kansas Uniform Directed Trust Act. You received the bill last year, and it looks like you had your hearing on February 8th of 2021, so right about a year ago. So it is still here in the committee. It can still be acted upon. I just wanted to double check that. If you go back to your file, it looks like you have a fairly maybe not detailed, but a fairly substantial bill
I'm
brief.
sorry, hold on just a moment. Do we have that? We probably don't have that in our committee folder. So
Probably not.
if the committee is not comfortable with moving forward on this today, we can, I think the correct word is table it for a different day, or put it back on the agenda for a different day. So we will add that to our committee folders, and we will take a look at that for next week. And it was kind of switching gears from our law and order and law enforcement activities, looking at bills today. So we will put that on the possible final action on bills previously heard for next week. With that, then, I do want to advise committee and those in the committee meeting room and following along online that we will be putting out a revised agenda for next week to hear some bills and obviously possible final action on bills. Next week is the last full week before to hear Senate bills that are not exempt from having gone through exempt committees. So we will be meeting Monday through Friday next week. So please look for that revised agenda to be put out probably later today. And also then our last item on the sort of unofficial agenda is we do have a birthday in one of our, for one of our committee members, that's tomorrow. Senator Bowers shares a birthday with President Lincoln. So happy birthday tomorrow. And with that then, committee, have a good weekend, and we are adjourned.